Hello and welcome to Courts Today by Live Law. Let's get to today's top legal updates. Supreme Court seeks union ECI stand on lifetime bar for MPs or MLAs after conviction. Says, how can convicted politicians come back? Cycle tracks not priority when state struggling to provide basic needs like housing and hospitals. Supreme Court refuses to entertain PIL. It's a poem with a message of non-violence. Supreme Court questions Gujarat FIR against Congress MP over poem. Supreme Court acquits man on death row. Cites faulty investigation and gaps in prosecution case. Abuse of process. Supreme Court quashes cheating case filed against parents of man for breaking marriage promise. Delhi High Court grants custody parole to MP engineer Rashid to attend parliament. Proscribes him from using internet or speaking to media. Ratan Tata is well-known personal name, needs to be protected from unauthorized use by third party. Delhi High Court. I'm your host, Syed Amer Hussain, with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the end and don't forget to like, share and subscribe to our channel, because your support means the world to us. Starting with the first important news today, in a PIL challenging election of convicted persons as MP MLAs, the Supreme Court observed that criminalization of politics is a very major issue and sought the responses of Union of India and Election Commission on the challenge to constitutional validity of sections 8 and 9 of Representation of People Act. A bench of Justice Dipankar Datta and Justice Manmohan was dealing with a public interest litigation initiated by Advocate Ashwini Kumar Upadhyay, seeking lifelong disqualification of MPs and MLAs who have been convicted of criminal offences. It may be recalled that while this PIL, the petitioner has also challenged provisions of the Representation of People Act, which only bar convicted politicians from contesting elections for 6 years after serving the jail term. At the outset of the hearing, senior advocate Vijay Hansaria, acting as amicus curiae, informed that despite many directions passed in the matter since filing of the PIL, about 5,000 criminal cases pertaining to MPs and MLAs remain pending. Coming to the next important update of today, the Supreme Court has refused to entertain a petition seeking direction to have separate cycling tracks in all cities, questioning the feasibility of such a direction when the governments were finding it difficult to even provide basic amenities like shelter and hospital to the people. At the outset, the bench comprising Justice Abhay S. Oak and Justice Ujjal Bhuyan took objection to the wide nature of prayers sought in the petition. Such reliefs can never be granted. How is it possible? You are treating India with a European country that every city should be having a cycle track? Justice Oak said, we can't compare India with Netherlands. Justice Bhuyan added, the petitioner submitted that he was seeking directions for non-motorized transportways, which will include both pedestrians and cyclists, and claimed that this will cover about 60% of the population using roads, especially the urban poor. Nearly 50% of the road accident victims are pedestrians and cyclists, he stated. In another big update arising out of the case on the poem, "A Khoon ke Pyase Baat Suno," the Supreme Court on Monday, February 10th, questioned an FIR registered by the Gujarat police against Congress Rajya Sabha MP Imran Pratapgadhi over a poem posted on social media. A bench comprising Justice Abhay S. Oak and Justice Ujjal Bhuyan, considering a petition filed by Pratapgadhi challenging the Gujarat High Court's refusal to quash the FIR, observed that the police has not appreciated the true meaning of the poem. Senior advocate Kapil Sibbal for the petitioner said, the judge has done violence to the law. That is my worry. The bench ultimately adjourned the matter by 3 weeks at the request of the counsel for the state. Please apply your mind to the poem. After all, creativity is also important, Justice Oak told the State's Council while adjourning the matter. Up next, the Supreme Court set aside the conviction of an accused convicted of the death penalty in a case for allegedly committing the gruesome murder of his 6 family members, including his 4 children and brother. The court cited faulty investigation and flawed recovery of evidence by the Uttar Pradesh police. The fabric of the prosecution case is full of holes and holes which are impossible to mend, the court said. The court noted that the prosecution failed to prove any incriminating circumstances such as motive, last seen, and recoveries against the accused. A bench of Justices Vikram Nath, Sanjay Karol, and Sandeep Mehta heard the case. The prosecution case was solely based on circumstantial evidence, contending that the appellant murdered his family members due to a land dispute. However, it failed to prove the motive. The Supreme Court recently dismissed the cheating case, Section 415 IPC, against the parents for facilitating the marriage of their son to another woman instead of the complainant. Given the complainant's maturity and background, including her 29 years of age, postgraduate degree, and professional experience, the court found it difficult to believe the parents' conduct easily influenced her. The court observed that the trial against the parents would be an abuse of the process of law and should be nipped in the bud. The court also disapproved of the High Court's observation against the appellant's son, which suggested that quashing the case against his parents would enable him to exploit women of marriageable age in a similar manner. Emphasizing judicial fairness, the court reiterated that no adverse remarks should be made against a third party who was neither present in the proceedings nor allowed to be heard before the impugned judgment was passed. A bench of Justices Ehsanuddin Amanullah and K.B. Vishwanathan was hearing an appeal challenging the Madras High Court's decision refusing to quash cheating case against the appellants. The Delhi High Court today granted custody parole of 2 days to Jammu and Kashmir MP Rashid Engineer, who is detained in relation to a terror funding case registered under UAPA. Rashid sought custody parole in order to attend the parliamentary budget session. Custody parole is being granted for 2 days. In the peculiar facts of this case, conditions are imposed, Justice Vikas Mahajan said while pronouncing the order. The court has granted custody parole to Rashid for February 11th and 13th. Rashid has been restrained from having access to his mobile phone as well as internet. Verdict in the matter was reserved last week. The court heard senior advocate N. Hariharan for Rashid and senior advocate Siddharth Luthra for National Investigation Agency or the NIA. In the last news for today, the Delhi High Court has ruled that Ratan Tata's name is a well-known personal name and trademark which cannot be used without permission. The case was filed by Ratan Tata Trust against journalist Dr. Rajat Srivastava, who allegedly used Ratan Tata's name and photograph to promote an award ceremony, the Ratan Tata National Icon Award 2024 at Maharashtra Southern. The trust claimed that Srivastava was charging a nomination fee while falsely associating the event with Tata Trusts, Tata Group, and Ratan Tata. The court found this to be a clear case of fraud, stating that Srivastava was misusing Tata's reputation to deceive the public. Justice Mini Pushkarna ruled in favor of the trust, observing that Ratan Tata's name has gained a distinct identity beyond just being a personal name. The court held that the unauthorized use of his name and trademarks was a bad faith infringement meant to gain publicity and financial benefits.